Hi, this is Professor McLaughlin. I wanted to provide you guys with a brief lecture on Chapter 15 and motion practice. I want to provide this for the seminar that we're going to have on the 26th, but also this is such an important area for paralegals, motion preparation, being able to find what the court rules are, understanding what a motion is. Frequently, they are last-minute responses, reply motions to what the opposition has asked the court to do. It's something that the authors of this book and this online course, they don't spend a lot of time on it. I looked through the assignments, and so I'm actually quite pleased that we're going to focus on it. So last week, hopefully you read the motion for continuance information that I put on your blackboard. This week, you're going to do one activity in Chapter 15, and then next week we'll start back again with Lesson 6. And for those of you who can't attend the seminar, I'm going to record it, but I do believe that you can still submit the information, the affidavit, the statement of facts, the documents that we're going to be preparing that evening on the 26th. For everybody who can't make it, we'll find a way to also get you some practice in this area. So what are motions? After you have filed the complaint, the motions are really the way that you communicate with the court and make requests. You can have a motion to dismiss. This lawsuit makes no sense. Dear court, please dismiss it. But there are lots of other motions. The motion for continuance, which is the information that we'll do on the 26th, is, these dates don't work, I need more time, new law has come out. It could be various things, and you're going to ask the court to change the, hearing date. And then there's going to be an opposition to the motion or no opposition to the motion. But the opposition to the motion will be based on other facts, maybe law, and that opposition, no, I don't want the court to grant a continuance, or I don't want the court to dismiss this matter, will state other law that supports the court not deciding in favor of the motion. So one party moves, one party makes a motion to request an order from the court. And it happens both in civil and criminal cases. What you have in your blackboard and what we'll be doing on the 26th is a civil case. So in general, the motion requests the court's attention to make a decision, and let's say we're dealing with a pretrial motion before the hearing. And the motion can request a hearing date prior to the trial, prior to the underlying matter hearing, and that motion hearing will just be limited to what the motion is about, motion to continue. We need to move the date. One of the claimant is sick or new law has come out. We need more time. So the moving party will ask the court to have a hearing date. They'll serve documents. It's almost like a mini trial. You're going to serve the motion on opposing counsel. The court's going to get it just like you would do a pleading or a claim. The opposing party can reply and oppose it. We'll also file documents. And there's an opportunity, just like a tennis match, for the moving party to reply to the opposing party's response. So it's claimant's response to, defendant or respondent's opposition to the motion. So that moving party can reply. all of these documents and briefs and memorandum go before the court. The court can hear the matter where argument is made, just like a mini trial, or the court can just issue an order on the papers. It really depends. The court can read the judge can read all the papers that were submitted and then make a decision right then. Or the court can ask the parties to come in and argue. So the most common motions in civil cases are maybe motions regarding the pleadings. So maybe the pleadings didn't state a claim that relief can be made on. Maybe the pleadings were improper in some way. There can also be discovery motions, lots and lots of discovery motions. And discovery, as for many of you who have had civil litigation know, is the process where documents are exchanged, information is exchanged, investigations are made, depositions are taken. And discovery motions could be, hey, court, this guy's not playing fair. I asked for documents and they never provided them. And these are easy documents to provide, like a tax return or a spreadsheet that shows business activity, or a copy of a document that's commonly held, and they're not providing it, and court, I would like you to order the party to provide it. Or there could be a motion for a subpoena. Dear court, I'm having trouble getting this non-party to the trial or to the hearing or to a deposition. Please issue an order or a subpoena, and also ask them to bring the following documents. Other common motions in civil cases are summary judgment motions, where the court is able to make a decision without any hearing. Motion for new trial, many of these are covered in your book. Motion for relief from judgment or order, and really basically what I want you to know from your reading, and also from your work this week, is that the motion also must comply with the court rules of what it needs to look like, and the timing of it, and the format. In criminal cases, different kinds of motions. So for remembering that in a criminal case, it's the state, the prosecutor, who brings the complaint against a alleged criminal defendant. There are lots more constitutional protections in criminal law. The motions are gonna be different because most likely you're gonna have a jury. So motions for change of venue, maybe it's a very public trial. You need to find another place where you can get a jury pool who has not been reading in the paper all about this criminal case. You may want to suppress evidence. That motion based on Fourth Amendment, based on prejudice, based on lots of constitutional things, and also discovery motions. So the criminal defendant may want to see lots of police reports and information that the district attorney or the prosecutor needs to turn over. You have a motion to dismiss, just like civil, motion for acquittal, motion for new trial. So, and those criminal case motions, the paralegal and the lawyer also need to focus on what the court rules say, what the timing is, what they need to look like, what the format is. So, research requirements for the motion. You need to have a proper legal basis for the motion so that the court doesn't dismiss it outright. You'll need to show that you need to understand the procedural requirements, which is what I've been kind of focused on the last couple of slides, Make sure the motion has the proper format. It says everything it needs to say. The declaration is there. All the notices are there, affidavits if they're required, a memo of points and authority that needs to be included. Those are procedural rules, procedural requirements for the motion. And then you need to look up the substantive law. Were there other court decisions where this motion was approved? So substantive law, the black letter law, code provisions, or common law, this is where you're giving the court the support for making a decision in your favor. So you're going to say, many judges decided this motion in my favor, court. You don't need to worry about it. Here's all the support for that. Here are all the local Orange County or state of California cases that support a decision in my favor. And then oppositions to the motion do all the same things. Don't make a decision in their favor, judge, because here are all the problems with it, and it's unfair, and it's not proper, and here are all the cases that support opposition to this motion. So the supporting documents, some of what you'll be working on next week and this week in your assignment, you need to have notice of the motion, just like service of process. Notice that somebody is suing you. The memo of points and authorities, a very specific type of memo, and that is covered in your book. I'm not, gosh, I wonder if I should have made you read that. Well, you're not going to draft it, not really, for next week, but also typically I don't include that in the legal research and writing course because that is next level paralegal stuff, and really only a paralegal working for 10, 20 years is going to draft that memo. Usually it's going to be the lawyer who drafts it. The paralegal will do the legal research to find the support. But I may provide a little bit of some resources for you for the memo of points and authority. It has a specific format that's different than any other kind of memo. Other supporting documents, declarations and affidavits, and then there could be specific supporting documents for, the very, very, it could be, if it's a discovery motion, there could be supporting documents that have to do with whatever the request for production, the deposition, whatever it is. And then a draft order. So providing the court a already prepared order that they just need to sign saying, yes, this approve my motion, or the motion is ordered. Okay, and so we haven't spent a whole lot of time on the blue book. I do want to get into it. You don't have a lot of slides in your Blackboard, maybe one or two. But the blue book, if I haven't lectured on it before, is it's the handbook for how legal citation should look in all legal documents to the court, or predictive documents such as a legal memo, law journals, articles, and it is the proper format for citing to cases, citing to other code provisions, and is similar if many of you have written for an English course or a history course, it's similar to MLA or APA, but it's legal specific. So the blue book is an actual book. It's also online. And these slides cover, is that the last slide? How you would cite in court documents and litigation documents. So what I think I'll put on your Blackboard is a sample memo of points and authorities, so you can take a look at that. I don't think we provided that. The lawyer who is teaching on the 26th provided that, but I'll provide a copy of that. Okay, so just a real quick, I'm wrapping it up. That's chapter 15, and I will create an upload spot for the work you're going to do this week. All right, bye.